Okay, so you've been working hard on your patent application, you navigated examination, maybe even an RCE, and now you've appealed to the Patent Trial and Appeal Board. You've waited, perhaps had that hearing, and then the decision lands. What does that actually mean for your case? What comes next? Welcome to the deep dive.
That really is the critical moment, isn't it? And as you know, this series takes you section by section through the MP, the Manual of Patent Examining Procedure. We're aiming for accessible explanations of all these rules.
Right, giving you that structured guidance through what can be, let's face it, a pretty complex document.
Exactly.
And today, we're decoding a really crucial section, MPP Section 1213. This is nested in Chapter 1200, the Appeal chapter. Section 1213 specifically details what the board, the PTPK, can do after reviewing your appeal, their powers, their options, and maybe most importantly, your options after their decision.
So our mission today, you could say, is to guide you through those potential outcomes. What happens when the board rules? And what does the MPT say you need to do next?
Yeah, whether you're studying for the patent bar or, actively managing appeals, understanding this section is just non-negotiable.
Absolutely critical.
Okay, let's unpack this then. What are the basic ways the board can rule? What are their main powers here?
Well, at the most fundamental level, MPP, Section 1213, says the board can either affirm or reverse the examiner's decision.
Okay.
And they can do that in whole, agreeing or disagreeing with everything, or in part, where they might agree with one rejection but reverse another, for instance.
Right. So affirm means the examiner's rejection. It stands.
Generally, yes. An affirmance basically upholds that ground of rejection. The claim stays rejected on that basis, unless the board specifically says otherwise in their decision.
And reversal, does that mean, okay, great, the claims are allowed now?
This is a super common point of confusion. MPP 1213 is very clear here. A reversal is not a direct instruction to allow the claims.
Okay.
It simply removes the specific grounds for rejection that the examiner raised and that were actually reviewed by the board on appeal.
Got it. So if the examiner rejected a claim for, say, 2 different reasons, and the board only reverses one of those reasons,
then the other reason still stands. Or maybe there's another issue lurking that wasn't even part of the appeal. A reversal clears the appealed rejections, but that's it.
what about claims the examiner had allowed? Does the board look at those?
Typically, no. The MPP notes the board isn't expected to sort of re-examine allowed claims, but, and this is important, they definitely have the authority to reject even those previously allowed claims if an issue becomes apparent to them during their review of the appealed claims.
Wow. Okay, so even allowed claims aren't totally safe until the whole appeal is done? That's a key detail.
It really is.
Beyond affirming or reversing, what's the other main thing the board can do?
They can issue a remand. This basically sends the application back down to the examiner.
Why would they do that?
Often for further examination or maybe to clarify specific points the board needs more information on before they can make a final decision.
Okay, so affirm, reverse, maybe a mix or a remand. Let's follow that remand path. Board remands, examiner issues a substitute examiner's answer addressing the board's points. What happens then? What are the applicant's choices?
Right. This is a really critical fork in the road procedurally.
Yeah.
And there's a tight deadline. You have exactly 2 months from the mailing date of that substitute answer.
It's 2 months. Okay. What are the options within those 2 months?
MPP 1213 lays out 2 main options. Option 1, you can essentially choose to reopen prosecution
How?
by filing a reply under 37 CFR Section 1111. This reply needs to directly address the rejections or points raised in that substitute answer. It pushes the case back into examination for those specific issues.
Okay, reopen prosecution. What's option 2?
Option 2 is to continue the appeal. You do this by filing a reply brief under Section 41.41.
So strategically, reopening sounds more flexible, maybe add new stuff.
Generally, yes. Reopening gives you that chance perhaps to introduce new arguments, maybe new evidence, or even amend the claims in ways you couldn't during the main appeal briefing. Continuing with just a reply brief is usually faster, but much more limited in scope.
And this is where that tricky point about adding new material comes in, isn't it? What if you try to put new amendments or evidence into that reply brief?
Yes. Big warning sign here in MP 1213. If your reply brief, the one meant to continue the appeal, includes new amendments or new evidence that wasn't already part of the record.
Oh.
Yeah. The office won't treat it as a proper reply brief continuing the appeal.
It doesn't just get considered.
Nope. MPP 1213 says it will be treated as a request to reopen prosecution.
Wow. So trying to like sneak new stuff into the reply brief automatically kicks you back into examination mode.
Exactly. It's a procedural trap you definitely want to avoid if your goal is to continue the appeal quickly. Makes that initial choice even more critical.
Definitely. Okay, so that covers remands. Now, you mentioned earlier the board isn't just reacting to the examiner. They can find their own reasons to reject a claim.
Absolutely. This is a major power. The board can introduce what's called a new ground of rejection. You'll often hear it called a board new ground, or NGR.
How does that happen?
If, during their review, they become aware of a valid reason to reject a claim that the examiner didn't raise, they can raise it themselves. Maybe they spot a better prior art reference in the record, or see an issue under, say, Section 101 or 112 that wasn't argued before.
So they can basically do the examiner's job, in a way, if they see something.
Well, they can identify new grounds based on the record before them. And crucially, MPP Pool 13 clarifies that these board-introduced NGRs are considered non-final at this stage.
Non-final, meaning you get a chance to respond before it's like game over for that issue.
Exactly. It's not final for judicial review purposes yet. You get a shot at responding directly to the board's new ground.
Okay, so the board hits you with an NGR. What are your options then? Similar to the remand situation.
Very similar concepts, yes. Two main paths. Path 1, reopen prosecution.
Again.
Yes. This lets you submit new evidence or file amended claims specifically designed to overcome whatever new ground the board just raised. You know, if they cite new art, you might amend or submit technical evidence.
Makes sense. And path 2.
Path 2 is to request a rehearing under 37 CFR section 41.52.
A rehearing. So you argue the board got it wrong.
Pretty much. If you choose this, your request has to specifically argue why the board's reasoning or the basis for their NGR is incorrect. You're challenging their legal or factual conclusion directly.
Can you give a quick example to make that clearer?
Sure. Let's say the examiner allowed claim 1, but the board, reviewing everything, finds reference Z in the record, which they believe shows claim 1 isn't novel. They issue an NGR based on reference Z. Your options. 1, reopen prosecution. Maybe you amend Claim 1 to add a feature not in reference Z, or you file a declaration showing reference Z doesn't actually teach what the board thinks it does. Or 2, request rehearing, arguing, for instance, that the board misinterpreted reference Z, or that Z doesn't actually anticipate all the limitations of Claim 1 as written.
Got it. So the choice really depends on the nature of the NGR and whether you need new evidence or just need to argue the existing facts law differently.
Precisely. And related to this, if you think the board made a new rejection but didn't explicitly call it a new ground.
Like it's sort of hidden in the reasoning.
Kind of. The MPP says any such undesignated new grounds must be challenged by filing a request for rehearing. You have to point it out and argue against it that way.
Okay. That covers decisions, remands, NGR's responses. What other sort of procedural nitty-gritty does MPP 1213 cover? Any traps?
A really big one, and this trips people up all the time. Extensions of time.
Always important.
MPP 1213 makes it crystal clear that the standard, almost automatic extensions of time you can get under Section 1.136A, the ones you often just pay a fee for during regular prosecution.
Yeah.
They do not apply to the deadlines in this section, like that 2-month deadline for responding to a substitute answer or the deadline for responding to an NGR.
So you can't just buy more time easily.
Correct. For these specific appeal-related deadlines, if you need an extension, you have to request it under the much stricter provisions. That's Section 1.136B for applications, which requires showing sufficient cause, a higher bar, or Section 1.550C for ex parte reexaminations.
That is a critical distinction. Huge practical point. What else? Can the board ask for more info?
Yes, the MPP explicitly gives the board authority to require additional briefing from either party if they feel it's necessary to really understand the issues or arguments before making a decision.
Okay. And you mentioned earlier about remands and finality for judicial review. Can you just clarify when a decision is final if there's been a remand?
Sure. This is key for knowing when you can appeal further, like to the Federal Circuit Court. If the board's decision includes a remand instruction, sending it back to the examiner for more work, that decision is considered non-final.
Right.
The case has to go back down, the examiner has to do whatever the board instructed, and then the case has to come back up to the board. Only when the board issues a subsequent concluding decision that resolves everything after that remand process is complete, only then is the decision considered final for judicial review.
That makes sense. The whole loop has to close first.
Exactly.
Are there times the board might delay making a decision even before a remand, like just hold off?
Yes, that can happen too. The MPP notes the board might decide to delay or suspend issuing its decision if there's, say, a parallel court case happening, maybe even a federal circuit appeal on a related application that could affect the issues in the appeal before them.
Trying to avoid conflicting results, presumably.
Precisely. It's seen as prudent to wait sometimes to avoid the board ruling one way and a court potentially ruling differently on a similar issue.
Can we, as applicants, ask for a delay?
You can. Appellants can file a petition asking the board to hold off on their decision.
Why would someone do that?
Often it's because they plan to refile the application, maybe as a continuation, and hope to resolve the issues that way, making the appeal moot. The MPP does suggest these petitions are looked upon more favorably if filed early in the appeal process, especially before an oral hearing is scheduled.
The timing matters there, too.
Okay,
Okay, one last thing. MPA 1213 apparently includes a specific warning or caution from the board about how to read their decisions.
It does. It's a very practical point, kind of a don't read too much into this warning.
Okay.
So the board might say something in their decision like pointing out that a specific feature of your claim is missing from a prior art reference they discussed.
Like reference X doesn't teach element Y of the claim. Something like that.
Exactly that kind of statement. MPP 1213 specifically warns applicants not to interpret such statements as the board giving you a hint or like pre-approval that if you just amend the claim to add that specific missing feature, it will automatically be allowable.
They're not giving you a roadmap to getting the patent allowed?
No, definitely not. Their job is to review the rejections and arguments based on the claims as they are. Their comments are confined to that analysis. They aren't giving advisory opinions on how you could amend the claims to make them allowable. It's a subtle but important distinction.
That really clarifies their role. Okay, so pulling all this together, what's the big picture takeaway from MPP section 1213?
Well, understanding the section means you're prepared when that board decision arrives. You know the potential outcomes. Affirmance, reversal, maybe a mix, or a remand.
And you know those critical timelines and choices, especially after a remand and substitute answer that 2-month window, the choice between reopening prosecution or filing a reply brief, and the huge caveat about not adding new stuff to the reply brief.
Exactly. Plus, you're ready for the possibility of a board NGR, a new ground of rejection, and you know your two main responses. Reopen to submit new evidence or amendments, or request a rehearing to argue against the board's reasoning.
And don't forget, those procedural points, standard time extensions don't apply, you need a special request. And decisions with remands aren't final for court appeals until the whole thing comes back to the board.
Right. Knowing all this really empowers you to navigate what happens after the decision, whatever it may be. It takes away some of the uncertainty.
It definitely makes the process less opaque. So here's something to think about. A provocative thought, perhaps. Given that the board can introduce entirely new grounds of rejection, how might that possibility shape your strategy when you're writing your initial appeal brief? Does knowing the battlefield might expand influence how you frame your arguments against just the examiner's points?
That's a great question. Thinking ahead about potential vulnerabilities the board might see, even if the examiner missed them, yeah, that could definitely influence brief strategy, something to really mull over.
Indeed. Before we wrap up, we want to give a special thank you to Mike Shepard, the creative director who organized this entire audio series.
Yes, his work behind the scenes is invaluable.
And finally, our standard disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It's for general educational and informational purposes only. It is not legal advice or a substitute for formal instruction.
That's right. For any authoritative guidance, please consult the official MPEP itself, a qualified instructor, or of course, a registered patent practitioner. Always check the primary sources for your specific situation.
Thanks for joining us for this deep dive into MPP Section 1213. We'll see you next time as we continue unpacking the MPEP section by section.